Welcome to Alka Legal. In today's video, we are discussing how to draft a valid contract in Ghana. Many a times, you would find some business stakeholders entering into transactions without a written contract. Terms of their agreement may be scattered in conversations, text messages, emails, WhatsApp chats, invoices, and so on. This may have been working for a while, but you need to know that as your business grows, so do your risk, and you do not want to depend on such unreliable means when disputes arise. A written contract will help to set the expectations of the parties clearly. It will reduce misunderstandings and protect your business. So whether you are selling a product, offering a service, or hiring someone, a written contract will help to keep all the parties involved accountable. A valid contract is one that binds the parties and can be enforced by law. It may be oral or written. An oral contract is simply one that is made verbally, no documents involved. This can be enforced if you can prove that all the essential elements of a valid contract existed. However, it's tricky because without sufficient evidence and witnesses, it's just going to be your word against the word of the other party. A written contract, on the other hand, is simpler to prove because everything is documented: the parties, the terms, and their signatures. So if it matters to you, then please put it in writing. Now, for a contract to be valid, it has to include certain essential elements. These are offer and acceptance, consideration, capacity, intention to create legal relations. And in addition to this, your contract has to be clear and not ambiguous, and it shouldn't be for an illegal purpose. In this video, we cannot go into the details of the element. We are going to look at some basic clauses to include in your contract to make sure that you are meeting the elements of a valid contract. The first basic clause to include is parties. Your contract has to clearly define the people who are entering into the agreement. This will help you to determine those who are bound by the contract and therefore can enforce it. It will also help you to determine the capacity of the parties in the contract. If they are individuals, state their full names and residential addresses. If they are corporate bodies, ensure they are registered and state their registered names and registered addresses. The second basic clause is specific work or scope of work. In your contract, clearly define the reason for entering into the contract. Make it clear and not vague. So, if for instance your contract is for the supply of cement, then instead of just stating that party A will supply cement to party B, you may clearly define it by stating that party A will supply 100 bags of X cement to party B at their registered address within 10 days of signing the contract. This is more specific and may be easier to prove. Another basic clause to include in your contract is duration, termination, or deadlines. This clause may be put under one clause or may be different clauses. Duration will determine when your contract starts and ends, and termination will determine when a party can end the contract. Deadlines will also show the parties when they are supposed to do certain things. These clauses will help you to determine when liability starts and when liability ends. Deadlines will also help you to track the performance of your agreement and avoid delays. If your transaction has specific areas that has to be performed by certain parties, then you need a clause on roles and responsibilities which will define the specific duties to be performed by each party. It will avoid confusion and doubt. Also, if your contract involves the sharing of sensitive and personal information, then you need a clause on confidentiality and data protection to protect the information and define consequences and remedies in case of breach. Another basic clause to include in your contract is dispute resolution and governing law. At the beginning of a transaction, I assume the parties expect that everything should run smoothly. Unfortunately, that is not always the case. Disagreements may come along the way. This clause will tell the parties what to do, whether they should go to court straight away or they can settle the matter out of court. This clause will save you time and money, and to avoid being dragged into expensive litigation or foreign countries to settle disputes, especially when you are dealing with foreign clients. After you have included all these basic clauses and other terms you want to include in your contract, ensure that your agreement is signed. Without signing the agreement, it may be very difficult to enforce it. Electronic signatures are valid in Ghana, so don't let signature be the reason why your contract cannot be enforced. Now, take note of these tips to save you from unnecessary risks in future. First of all, use plain language. Avoid using complicated language in your transactions, which will make it difficult for the parties to understand or for the courts to interpret. 2, be careful of downloading foreign templates because most of these templates do not apply in Ghana. 3, get witnesses. One witness for each party is enough to give weight to your contract. Also, keep records. Have soft copies and hard copies of your contract for future reference. Drafting the contract doesn't have to be scary. Just focus on clarity and documentation. However, you need to take note that the nature of certain contracts may require some legal help. And don't forget, a handshake is good, but a signature is safer and better. If you learned something from today's video, then you can share with someone else to also benefit. You can also tell me in the comments the clauses you've been including in your contracts. Thank you for watching Alka Legal. See you in my next video.